Hello students, today we are going to deal with the topic of ethics and legal issues in print media. Media should act as watchdog for the society, and so they have a right to cover anything that is new dimension in the society or that has an impact on the society. The explosion of investments in the area of news is the main reason for the news people getting into marketing mode rather than stay in the mode of being watchdogs and communicators to the society. These conditions led the focus towards business ahead of journalist ethic. The judgment now is if something is newsworthy. The matter of concern now is, should media cover those potentially dangerous aspects of the society at prime time to protect the interest of a very small section of population, even if such a story impacts the larger section of the society adversely? The term unethical is used in connection with media either to mean prohibited or not allowable. The Press Council of India has been established with the object of preserving the freedom of the press and of maintaining and improving the standards of newspaper and news agencies in the country. The council over the years has built up a code of ethics covering aspects of journalism. The ethics are not imposed on the profession from outside but are evolved by itself. The fundamental duty and responsibility enjoins on the profession many other moral and ethical obligations like need to verify from all possible sources the correctness of their stories, particularly libelous and defamatory material before publication. Need to exercise utmost caution in reporting communal disturbances, scrupulously avoiding inflammatory material. While publishing letters to the editor or covering proceeding of Parliament, duty to give a balanced picture, taking views of all sides involved and not to publish unverified, baseless, graceless, misleading or distorted material. Not to condemn anyone unheard. Not to invade a person's privacy except in clear public interest. Not to steal another person's writing, that is used another author's writing as your own. Not to criticize the judicial acts of a judge adversely affecting the administration of justice. The ethical guidelines prescribed for the print media are not exhaustive but only selective to bring home the fact that the purpose of codifying the ethico-moral principles is to make the press fully responsible to the society as a whole and to be fair to individuals so that the print media functions in the best interest of the people. Code of Ethics for the Press in Reporting and Commenting on Communal Incidents adopted in 1968 at All India Newspaper Editors Conference. A free press can flourish only in a free society. Communalism is a threat to the fabric of our free society and to the nation's solidarity. The press has a vital role to play in the consummation of the fundamental objectives enshrined in our Constitution, namely democracy, secularism, national unity and integrity, and the rule of law. It is the duty of the press to help promote unity, cohesion in the hearts and minds of the people and refrain from publishing material tending to excite communal passions or inflame communal hatred. To this end, the press should adhere to the following guidelines in reporting on communal incidents in the country. All editorial comments and other expressions of opinion, whether through articles, letters to the editor, or in any other form, should be restrained and free from scurrilous attacks against leaders or communities, and there should be no incitement to violence. Besides these wire agencies, a large number of agencies which deliver news material and articles by hand or mail, like the old established India Press Agency, INFA, India News and Feature Alliance, and Press Asia International, and several agencies in Delhi and outside. Some, as we will see, in Hindi, Urdu and other languages. There are also photo agencies and a cartographic service. Photojournalism as well as cartoons has developed fast, and a newspaper can hardly afford to go without either. There are also agencies in the electronic field for the benefit of subscribers at home and abroad. Amongst all these news agencies, PTI and UNI have made a great impact in the distribution of national and international news in India. There are also press organizations that control the press regarding the news that will be published. Audit Bureau of Circulation Limited, ABC. The ABC is a private body whose members are 252 regional and national publishers and 208 leading advertisers, news agencies and advertising agencies. It surveys the circulation of publications in English, Hindi and 12 regional languages in more than 80 major Indian towns. It carries out circulation surveys on regular basis and issues certificates of net paid circulation every 6 months. It has a very high reputation for reliability and impartiality. Therefore, it is quoted with authority. Another press organization is Registrar of Newspapers for India, RNI. RNI functions as central government body responsible for the compilation of a register giving particulars like ownership and circulation of all newspapers published in India. It oversees the allocation of titles, newsprint and certificates for the import of printing and allied machinery required by newspaper establishments. It also sees to the enforcement of the provision of the Press and Regulation of Books Act and has the authority to inspect newspapers' records and documents. It carries out frequent checks to find out whether the newspaper registered with it are published regularly and also whether the circulation figures claimed by newspapers are credible. It compiles the annual report of the press in India. The Press Information Bureau, PIB. PIB is the central agency of the Government of India. It disseminates information on government policies, decisions, programs, initiatives and activities. It puts out this information to daily newspapers, periodicals, news agencies and All India Radio and Doordarshan. It provides feedback to the concerned ministry or department of the Government of India regarding press relations and nature and extent of publicity measures to be adopted. It accordingly advises the Government of India on its information policy. According to the Constitution of India, there are various laws that govern the print media. They are Press Council of India, Constitutional Law of Press Freedom, Press and Registration of Books, Official Secrets Act, Contempt of Courts, Privileges of Parliament, Working Journalists Act, Copyright Act, Law of Defamation. India is one of those countries which guarantee their citizens the right to freely express themselves. The Indian Constitution guarantees fundamental freedoms and the freedom of speech and expression is the first among them. Article 19(1) of the Constitution reads, all citizens shall have the right to freedom of speech and expression, assemble peacefully and without arms, form associations and millions, move freely throughout the territory of India, reside and settle in any part of the territory of India, practice any profession or to carry on any occupation, trade or business. Thus, all Indian citizens enjoy a constitutional right and give free expression to their views, opinions and convictions. They have for this purpose the right to seek. The PCI is also to promote a proper functional relationship among all classes of persons in newspapers and news agencies, concern itself with developments such as concentration of ownership affecting independence of the press, and take up any other studies related to the press that may be referred to it by the Centre. The objective of the PCI is to preserve the freedom of the press and to improve the standards and maintain their independence, build up a code of conduct for them in accordance with high professional standards, ensure maintenance of received by Indian newspapers and agencies from any foreign sources as referred to it by the Centre. The Centre can at the same time deal with such cases in any other manner it thinks fit. The Council may be entrusted with a study of impact and circulation of foreign newspapers and their correspondence. The newspapers may include embassy publications. The oldest surviving act in this regard is the Press and Registration of Books Act, 1867. It also remained the fundamental law governing the rules for the regulation of the publication of newspapers and of having printing presses. The Act requires that the name of the printer, the place of the printing, and the name of the publisher and place of publication must be legibly printed on every book or newspaper printed or published within India. For having a press to print books or newspapers, a declaration must be made before the district presidency or subdivisional magistrate giving description of its location. Two conditions are necessary to be fulfilled for publishing a newspaper. The name of the editor must be clearly printed on every copy of the newspaper. A declaration must be made before the district, presidency or subdivisional magistrate within whose jurisdiction the newspaper is to be published, stating the facts: name of the printer and publisher, premises where printing and publishing is conducted, the title, language and periodicity of the newspaper. The declaration should be made by the printer and publisher either in person or through an authorized agent. If the printer or publisher is not the owner of the paper, the declaration should specify the name of the owner, but making a declaration does not automatically pave the way for publishing a newspaper. Publication can be started only after the said magistrate authenticates the declaration. The Official Secrets Act 1923 is a comprehensive document relating to official secrets and defines a number of offences. The Act is aimed at maintaining the security of the state against leakage of secret information, sabotage and the like. However, many of the acts prohibited by this law may be committed by newspapers and journalists and private individuals while performing their duties. The Official Secret Act 1923 broadly has two parts, one relating to spying for the enemies. The punishment for spying in relation to the country's defense is up to 14 years. The other relates to unauthorized communication of any other secret official code or passwords or any sketch, plan, model, article, note, document or information. The provision of Section 5 is more important from the standpoint of the freedom of the press. The government, whose administrative culture is secrecy, has an internal system of dividing its documents into classified and non-classified categories. The classified documents are considered secret under various statutes such as top secret, secret, confidential and restricted personal note for publication. Laws against printing of classified documents are understandable in relation to certain areas like defense and security of the country. But the Official Secret Act also prohibits publication or communication of any information which may be directly or indirectly useful to the enemy. In India, it has been widely demanded that Section 5 of the Official Secrets Act, which inhibits free reporting, should be done away with. It prescribes a punishment with imprisonment up to 5 years or fine or with both for a person who voluntarily receives or communicates any official secret. The Act does so without defining an official secret. This means that any official information which has been deemed by the authorities as secret can be published only on the pain of punishment. Judiciary is the most important of three pillars of the government. It interprets laws. The judiciary settles disputes between individuals, between the individual and the state, among the various constituents of the states. In order that it is effective, all must have faith and confidence in its impartiality, fairness, and concern for the right of the individual, interest of the state, and good of the society. For this, its independence must be ensured. There must be no interference in its functioning and no attempt to intimidate or influence it. Any such thing shall be done on the pain of punishment. According to Section 2 of the Contempt of Courts Act 1971, contempt is of two kinds: civil contempt and criminal contempt. Civil contempt means willful disobedience to any judgment, decree, direction, order, writ or other process of a court, or willful breach of an undertaking given to a court. Criminal contempt means publication of any matter or doing of any other act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of any judicial proceeding, or interferes or tends to interfere or obstructs or tends to obstruct the administration of justice in any other manner. Scandalization here means scurrilous attack on the administration of justice or vilification of the entire judiciary, a particular judge, or a particular court. Privileges of Parliament. The concept of privileges of Parliament rests on the principle that a sovereign legislature should be able to perform its legislative and deliberative functions independently and effectively. For this, it should possess certain inherent or conferred powers to punish for breach of such privileges. Articles 105 subclass 3 and 194 subclass 3 of the Constitution empower Parliament and state legislatures respectively to enact laws codifying their privileges. However, neither Parliament nor any of the legislatures of the states has so far done so. Therefore, according to the Constitution itself, the privileges enjoyed by them are the same as and not more than those of British House of Commons. One has to wade through the rulings, customs and practices of the House of Commons and to seek guidance for the rules of business and conduct proceedings of the House. Breach of privilege of either House of Central or State Legislature is usually known as contempt of Parliament, like the contempt of courts. Working Journalists Act. The Working Journalists and Other Newspaper Employees and Miscellaneous Provisions Act 1955 is a welfare measure meant to regulate conditions of services of the people employed in the newspaper industry. It is related mainly to special provisions in respect of certain cases of retrenchment, payment of gratuity, hours of work, leave, fixation of revision of rates of wages, enforcement of the recommendations of the wage fixation machinery, that is, wage boards and wage tribunals, employees' provident fund, recovery of the money due from the employer. In order to fix to revise rates of wages, separate wage boards for working journalists and other newspaper employees can be set up under the Act. The wage board for journalists consists of chairman, 2 representing working journalists, and 2 independent persons. In the wage board for non-journalist newspaper employees, 2 persons representing them shall be included. The chairman of both the boards is to be an independent person who is or has been a judge of the High Court or the Supreme Court. The central government may fix interim rates of wages in consultation with the boards. Money due to an employee under this act can be recovered from the employer by the collector in the same manner as an arrear of land revenue and have it paid to the employee. Copyright Act 1957. A work of literature, drama, music, or art is an intellectual property. It must be protected from illegal copying and reproducing it. The Copyright Act 1957 accords this protection. The law is based on two competing considerations. The creator's property, that is, the original works, need to be protected, and the other one is for advancement of knowledge in the interest of the society, there should be some amount of freedom to produce parts of other people's copyrighted works. Copyright has been held to be right which a person acquires in a work which is the result of his intellectual labor. The primary function of the copyright law is to protect from annexation by other people the fruits of man's work, labor, or skill. In respect of the press, copyright means under Section 14 of the Copyright Act 1957, the exclusive right in the case of literary, dramatic, and musical work to do and authorize the doing in substantive form of any of the following acts, namely, to reproduce the work in any material form, to publish the work, to make any adoption of a work, to reproduce or publish translation of the work. Punishment for knowingly infringing or abetting the infringement of a copyright is imprisonment which may exceed up to 1 year or fine or both. Now we will discuss about law of defamation. The background of law of defamation is defamation or taking away the fame from someone is an offence punishable with imprisonment from the earliest times of civil government. There is no separate law of defamation in India. The Indian Penal Code IPC has 4 sections which define elaborately what constitutes defamation and what the defences and the punishments are. Defamation is of 2 kinds. The verbal defamation is known as slander and the written defamation is termed as libel. The ingredients of the offence of defamation are: an imputation concerning the person must have been made, such imputation must have harmed or there is reason to believe that it has the tendency to harm the reputation of the person concerning whom it is made. Imputation means an accusation against a person and implies an allegation of fact and not merely a term of abuse or insult. In order to constitute the offence of defamation, it is not necessary that an injury to the reputation of the complainant must have been actually caused. It is enough if the offending statement is made with the intention of harming the reputation of the complainant or with knowledge or reason to believe that it will harm his reputation. A false and defamatory statement concerning another, the unprivileged publication of the statement to a third party, if the defamatory matter is of public concern, fault amounting at least to negligence on the part of the publisher and damage to the plaintiff. In the context of defamation law, a statement is published when it is made to the third party. That term does not mean that statement has to be in print. Damages are typically to the reputation of the plaintiff, but depending upon the laws of the jurisdiction, it may be enough to establish mental anguish. Most jurisdictions also recognize per se defamation, where the allegations are presumed to cause damage to the plaintiff. Attacks on persons' professional character or standing, allegations that an unmarried person is unchaste, allegation that a person is infected with a sexually transmitted disease, allegations that the person has committed a crime of moral turpitude. While actions for defamation have their roots in common law, most jurisdictions have now enacted statutes which modify the common law. They may change the elements of the cause of action, limit when an action may be filed, or modify the defenses to an action for defamation. Some may even require that the defendant be given an opportunity to apologize before the plaintiff can seek non-economic damages. Section 500 IPC prescribes the punishment for defamation. Whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or with both. Section 501 of IPC makes printing or engraving matter known to be defamatory, and Section 502 makes sale of printed or engraved substance containing defamatory matter also offences punishable with simple imprisonment, which may extend to 2 years, or with fine, or both. The Press Council of India has been established with the objects of preserving the freedom of press and of improving the standards of newspapers and news agencies in the country. It is to further these objects that the Council is required, among other things, to help newspapers and news agencies to maintain independence, to build up a code of conduct for newspapers, agencies and journalists in accordance with high professional standards, to ensure on their parts the maintenance of high standards of public taste, and to foster a due sense of rights and responsibilities of citizenship, and to foster the growth of a sense of responsibility and public service among all those engaged in the profession of journalism. Now we have come to an end of ethics and legal issues in print media. Do you have any questions?
Yes, ma'am. This is Meenakshi. I have a doubt. What is Press Academy?
Good question. Some states in India has constituted Press Academy with the noble object of promoting the highest and pro-people standards in journalism. It also aims at fostering values that help the society through communication media. Most of the rural stringers and correspondents did not have any professional background in journalism. Some of them were self-taught and picked up the threads of journalism in short time, while a large majority of them require a little help by way of professional advice, guidance and training. Press academies were established to provide them access to professional inputs on various topics of journalism, such as the law of libel and the law of relating to the privileges of the members of assembly and parliament, the concept of code of ethics in journalism, etc. Since there is a large ever-growing community of journalists in society, there is every need to look after the welfare, working conditions and further improvement of professional standards of the community. It is with these needs in view some states have constituted press academies. Any other questions? Now we have discussed the ethics and legal issues in print media. Thank you.